What's up, everybody? We are here today with a very interesting response filed by the state in the state of Indiana v. Richard M. Allen, aka this Delphi case, where we went through some of the wildest theories and accusations I've seen in a motion ever by the defense team. We talked about Odinism. We talked about cops lying on search warrants. We talked about fruit of the poisonous tree. We talked about potentially an innocent man living in hell with people that are connected to a cult abusing him while in that prison system, and all sorts of things in that motion filed by the defense. Well, we wondered if the state was going to respond and how they were going to respond, and we get our answer today. The state has responded, and they make some very good points that we're going to go through. But I think one of the things I want to focus on is what is not in the state's response. What do they fail to address? What do they ignore and why? And we can talk about that as we go through it today. I'm going to want to hear from you all in the comments. If you see something that state doesn't address, put it in the comments. And if you have a reason why, put it in the comments, because I'm really interested in how you all see this as well. We're going to read this entire objection filed by the state together. So hit that like button if you haven't already. Subscribe to our page in order to take part and have your voice heard in what content we cover and what cases we cover, because that's what I want to do. I want to talk about the cases you guys are most interested in so we can learn about the legal system together. So let's get into it here. This was filed this week, I believe. Yeah, September 25th. So yesterday. And it is the state's second objection to the defendant's motion to suppress. So this is the one that's basically responding to, that I've seen at least, to all of the crazy stuff we talked about last video. So come state of Indiana, prosecuting attorney. And what do they say? Number one, that on May 19, 2023, the defendant filed a motion to suppress the evidence seized as a result of a search warrant executed on the home of the defendant. Then on September 13, 2023, the defendant filed an amended motion to suppress that evidence seized as a result of the search warrant executed on the home of the defendant. Number three, the defense alleges, I hate the and that on, because it technically makes sense, because they say states the following. They state that on May 19th, but it's just not the way my brain works. So I always just say the defense alleges that the search warrant is unconstitutional because its issuance of a search warrant was a result of improper ex parte application, in that the affiant, Tony Liggett, failed to advise the judge of material facts and made false and misleading representations with reckless disregard for the truth, and that without these false and misleading representations and omissions, the search warrant would not have been issued. And to be clear, this is the Franks hearing that we talked about, and these are the elements that they had to leave stuff out, lie. And without those lies, and if they would have put in the important information that they left out, then the judge would have never found probable cause for that search warrant, and therefore, fruit of the poisonous tree, anything they found, including the firearm. This is commonly referred to as a Franks hearing. All right. That per the Franks case, the defense's attack must be based on deliberate falsehood or acts of reckless disregard for the truth, and those allegations must be accompanied by an offer of proof. That the claim should point out specifically the portion of the warrant affidavit that is claimed to be false, accompanied by a statement of supporting reasons. That further, this should be supported by affidavits or sworn statements or other reliable statements from witnesses or an explanation of their absence. So it's important to point out what we're looking for and what the defense should have done. The defense has filed such a memorandum outlining their beliefs of what was omitted and false. Once again, while the memorandum is colorful, dramatic, and highly unprofessional, so some shots going back and forth, it seems like we're seeing this more and more in these cases. So they agree it was colorful, dramatic, and highly unprofessional, but they say it is not completely true. So that little phrase there, it is not completely true. Number one, the defense called law enforcement liars, basically, and this side of the case, the state side of the case, liars. Well, and the state's now saying, well, actually, defense wasn't honest in their filing, so they're liars too. But they put in the qualifying term of completely true. So it wasn't completely true, which would also infer that there were parts of it that were true. Let's see if we can figure out if they mention which parts were true or just what we think is true based on what we've read in the statements and evidence that we've seen. The state believes the allegations outlined by the defense are not supported by evidence that they have collected. Sheriff Tony Liggett did not intentionally or recklessly omit evidence or lie about evidence in the probable cause affidavit to support the search warrant. So they just basically completely disagree with that, which they have to, obviously. The defense also alleges that the search warrant was unreasonable under the Indiana and federal constitution in that it lacked probable cause. It failed to establish that the items to be seized were in the residence or could be expected to be in the residence, that the affidavit failed to provide particular information that particular items related to the particular crime would be found in the home, and that the affidavit failed to connect generic items to actual items that were possibly used in the crime. So this is basically what we've seen in a lot of these affidavits, which is you have to be somewhat specific of where you're searching, what you're looking for, and what you're going to seize, and then letting them know what you seized in the end. And we'll look at what the state says, how they handled this process, and if they handled it appropriately. In September of 2022, while reviewing the evidence in the investigation into the murders, investigators discovered an interview that was done with Richard Allen in 2017 by Officer Dan Doolin. In 2017, Richard Allen admitted to being on the trail that day, the day that Abigail and Liberty went missing. He stated that he was on the trail between 1:30 and 3:30 p.m. and that while he was on the trail, he was using his phone. Then on October 13th, 2022, investigators invited Richard Allen and his wife, Kathy, to speak to them and follow up on that interview done in 2017. That both Richard Allen and Kathy Allen came to interview on their own. They came on their own in October of 2022. They were not under arrest and were free to leave at any time in the interview. Okay, so they came of their own volition. Again, it's interesting because he was interviewed at first and he was there and admitted being there. And then he came with his wife 5 years later, but still before he got arrested. So to think that he never admitted it to his wife or his wife never asked him, I think is interesting. Not interesting that most people deny things that they do, until they're convicted and sometimes even after they're convicted. But I do think that there is an element of mental distress that the defense is going to argue with the confession to his wife on the jailhouse phone call that happened later in the case, because they had plenty of opportunities to talk about it before now. Investigators learned from those interviews that they came to voluntarily that Richard Allen reaffirmed that he was in fact on the trails the day Abigail and Liberty went missing and further admitted to being on the high bridge. He also told investigators he was wearing blue jeans and a blue or black Carhartt jacket with a hood and that he was wearing a head covering. So why is this important? Well, this is all information that leads to probable cause to search this man's house. And the state is doing a good job of, instead of just reiterating the probable cause affidavit, they are saying, here is where we got this information from Richard Allen himself and his wife as to where he was and what he was wearing. It matches the description of at least one of the witnesses, and we put in that witness statement. The defense agrees they put in the witness statement. Now they say they didn't put in everything. And the other witness statements that maybe weren't corroborating or had some contradictions in them. But right now, the state's just laying the foundation where we absolutely had probable cause to search this man's house. And then what we found there gave us enough to arrest him. Further, Richard stated that he did own guns and that guns were in his house. Investigators learned from Kathy and Richard that they still had guns and knives in the home along with that blue Carhartt jacket. So what are we getting to now? Why did they need to search his house? Well, he had guns and knives and that blue jacket that he was wearing the night they went missing. He admitted that in the house. So therefore, you go and you search the house for those items. The investigators believed a firearm was involved in the abduction and killings of Abigail and Liberty because an unspent .40 caliber round was found between the bodies of Abby and Liberty. That .40 caliber round is what eventually they connect to Richard Allen's gun that they found in his house as a result of this search. So without all of that, the case gets a lot weaker. But knowing this information before getting probable cause to have the search warrant, before searching his house, before finding the firearm, to me is adding up to enough for probable cause, as we know, not the biggest standard in the world. I should say the highest standard. Investigators believe a knife was also used in the M's of them. The clothes Richard Allen described wearing that day on the trails matched the description of the man seen on the bridge from the video and from the video taken. That it was also gathered that Richard Allen still possessed the firearms, knives, and the clothings, and said items were in his house. Based on the information, investigators prepared a probable cause affidavit with a search warrant for the home of Richard Allen. The probable cause affidavit covers all the information that law enforcement had and gathered in the investigation in regards to Richard Allen up until October 13th, 2022. The probable cause affidavit outlines evidence that established probable cause to search the home of Richard Allen. Investigators for the search warrant on October 13th and the same was granted that day by the circuit court judge, Benjamin Diener. Investigators went to the residence of the defendant, knocked on the door, and executed the search warrant. The defendant and his wife were asked to be out of the residence while the search warrant was executed, but were allowed back in immediately afterwards. Investigators found several items in the residence, including a .40 caliber firearm and electronic devices, all of which were outlined in the search warrant return. By the way, an interesting part of all this, right, in the lawyering, and as we're making these claims and being real colorful and dramatic about things, the defense didn't try to explain why that spent .40 caliber bullet was between the bodies that matched Richard Allen's firearm, right? They never even touched that. They just kind of avoided it. And we're talking about Odin and all these things, and Richard Allen, nothing to do with it. Innocent man, this cult is reaching far and wide, but they don't mention that. In the same way, the state focuses on that, because that's a big piece of evidence for the state and an important piece of evidence for the state that how's the defense going to explain? Well, the defense is saying we shouldn't even have to explain it because it should get suppressed as fruit of the poisonous tree based on this unlawful search and seizure, based on the lies and the misrepresentations of law enforcement. For a search warrant to be valid, and now here's the scary part in our judicial system, is how low these bars are, and the state is going to admit it here. For a search warrant to be valid, it must be accompanied by an affidavit that establishes probable cause, which is the sufficient basis of fact that exists to permit a reasonably prudent person to believe the search of the premises will uncover evidence of a crime. And now that we know it has uncovered evidence of the crime, it's always hard, even for judges, to go back and think, is it enough to say that might happen when we know that it did happen, right? It's like saying Florida State's going to beat Clemson and me saying it now. Oh, I always thought there was a good chance we were going to beat Clemson. Well, if you ask me when we were down 24-17 before the fumble returned for a touchdown, I would not have expected that we were going to beat Clemson. I would not have thought it was probable that we were going to beat Clemson. I was sitting on the edge of my seat the entire time, basically miserable until we came back and finished it off. But now looking back, I can say, sure, it was probable we were going to beat Clemson because I knew we beat Clemson. Indiana Code 353352 specifies the minimum information necessary to establish probable cause. So let's read this here and tell me in the comments if you agree. Do you think this is enough of a threshold? Do you think it should be higher, or do you think it should be lower for cops to come and literally ransack and search your house? Information particularly described the house or place to be searched and the things to be searched for. Information alleging substantially the offense in relation thereto, and that the affiant believes, and has good cause to believe that the things sought are concealed in that place that they are attempting to search, or that the person to be arrested committed the offense. So do we think they actually believed that? And I think that's an interesting question. Information setting forth the facts known to the affiant through personal knowledge or based on hearsay constituting probable cause. So this is another interesting section. The facts known to the affiant, which is Tony Liggett, the sheriff, the one filling out this affidavit. In order to get probable cause, he has to let the judge know about these facts that he has through his knowledge or from hearsay talking to other people. Did he do that? The defense is going to argue he didn't. He didn't put down all the facts that he knew and that he got from hearsay with conversations with other people. And that's the problem. The state's going to say he did put down the facts he knew that were relevant. He doesn't have to put down every fact he knows. Under the Fourth Amendment of the United States Constitution, the evidence needed to obtain a search warrant need not rise to the statute of facts necessary to obtain a conviction. So it doesn't need to be beyond a reasonable doubt. We all agree there. But how high should it be? The circumstances alleged in the affidavit need only lead a person of reasonable caution to believe that a crime has been committed. So that's important. To lead a person of reasonable caution to believe that a crime has been committed. A lot of you are reasonable people, and when we talk through some of the things that this sheriff left out, a lot of you are saying maybe he is innocent, maybe we're not so sure. If we're reasonable people, maybe we wouldn't believe that he committed this crime. So that's the really tough part that I think we're going to have a hearing on, and the sides are going to argue is, did he actually provide them with the facts that he knew? And if he would have provided them with all the facts that he knew, would a reasonably cautious person believe a crime has been committed? That's how we break this stuff down. When the sufficiency of the search warrant is challenged under the Fourth Amendment by the defendant, as it is in the defendant's motion, the role of the reviewing court is to simply ensure that there was a substantial basis for finding probable cause. reminding itself that it owes great deference to the initial probable cause determination, which means we don't like to overturn ourselves. So once you win the first time, it's really hard to get that overturned. That's why appeals so often lose. And will not invalidate a search warrant by interpreting probable cause affidavits in a hyper technical rather than common sense manner. It's like, we don't want you guys to be hyper technical. Just take a skim of this and see how you look at it. And if it looks good enough, then shucks, let's go ahead and search this man's house. And hopefully we find something that connects him. Now they did. So there's two sides to this coin, of course. Article 1, Section 11 of the Indiana Constitution says the reasonableness of the search is determined by using the Litchfield test, which looks at the totality of the circumstances and requires consideration of both the degree of intrusion into the subject's ordinary activities and the basis upon which the officer selected the subject of the search or seizure. The inquiry requires a balancing of the degree of concern, suspicion, or knowledge that a violation has occurred. The degree of intrusion the method of search or seizure imposes on the citizen's ordinary activities and the extent of law enforcement needs. The state believes that the affidavit does meet the threshold to establish probable cause under the Fourth Amendment of the United States Constitution, and that there was a substantial basis for finding probable cause, and that there was a likelihood based on the evidence that investigators had that there was evidence of the crime in the home of Richard Allen. The state believes that the affidavit accompanied with the search warrant for the home of Richard Allen does establish probable cause under Article 1, Section 11 of the Indiana Constitution and does pass the Litchfield test for reasonableness under the totality of the circumstances. Well, that's good for us to know. The state believes the state was right. The state believes law enforcement was right. The state believes the defense is wrong, and the state disagrees with the defense. Shocker there. The state believes that the affidavit establishes the items to be seized were in the residence by statements made by Richard Allen and his wife, Kathy Allen. I agree with him there. State believes the affidavit provides particular information that the particular items related to the crime will be found in the home based on the statements. Agreed. The state believes that the affidavit connects generic items to actual items that were possibly used in the crime based on investigators' evidence that they gathered throughout the investigation. I agree. The evidence that was gathered in 2017 reaffirmed by the interview done with Richard Allen and Kathy on October 13, 2022. Investigators believed at the time that they had enough probable cause to apply for a search warrant. Investigators also believe that if they did not execute a search warrant on the residence immediately, that there was a danger that the defendant would destroy crucial evidence in the investigation. It's funny that they think that in 2017 he wouldn't have done that, but he would have waited 5 years and now he's going to do it all of a sudden. Interesting. Investigators believe through their training and experience that there was a real chance the defendant would destroy evidence once he knew he was a suspect in the crime. Wherefore, the state has shown that the actions by the officers were valid and justified and did not violate the Fourth Amendment, the defendant's Fourth Amendment under the United States Constitution or Article 1, Section 11 of the Indiana Constitution, and therefore the motion to suppress should be denied, respectfully submitted. Okay, so we read the whole motion there. And some interesting points there. I definitely think some things that the defense will take issue with, and we need to have argument in front of a judge. But I can't help myself but point out what the state did not mention in this objection to motion. And theoretically, they didn't have to mention some of this. They didn't mention Odinism once. They didn't mention the investigations by other law enforcement officers at all. They didn't mention the affidavits of those other officers. And I think their reason for that is they're going to say we were focused specifically on this probable cause for the search warrant, which is the big part of the motion to suppress that we're going to have a hearing on in this Franks issue. They focused specifically on the elements and the information needed to cross the threshold for probable cause for this search warrant. And they put together a very well-worded and I think succinct enough argument and presentation of the facts that do show there was probably enough for probable cause. Except that they also didn't mention any of the conflicting evidence, any of the conflicting eyewitness statements or descriptions or timeline or where the cars were parked. They didn't mention any of the other suspects, which I don't think they had to mention any of the other suspects, but very interesting that they didn't even mention any of the conflicting stuff either. And maybe the defense is going to say, if the state just thinks by not saying it, it makes it not exist. That's not how this works. They have to give the information and knowledge and hearsay evidence that they have, so a reasonably cautious person can determine whether or not a crime was committed here by this person, that we're going to go search his house and stomp on all of his rights. So what else did you come up with that they did not mention in this response? And why do you think they didn't mention it? Let me know in the comments, because I want to look through these comments and see what all the state just kind of, with one broad stroke, said. All that dramatic and unprofessional stuff that they threw in there, we're not even going to respond to it. And do you think they need to respond to all of it? Because legally, I don't think they need to respond to all of it at this point, because we're focusing on this motion to suppress. But eventually, and maybe it won't be until they're in front of a jury, they are going to have to respond to these other potentially legitimate suspects, even if they have alibis, and to all these Odin theories and comments made by law enforcement that there's a lot more evidence of other things than there is against Richard Allen. So for now, they haven't responded to it, but they're going to have to in the future. All right, that's all we've got for today's video. Hit that like button if you haven't already, and keep me posted on what you want to hear about. And as new things come out in this case, give us a follow on Instagram and Twitter. Lawyer You Know, or at Tragos Law, are our handles, depending on the site. So make sure you give us a follow in there and DM us more stuff as you see going forward in this case. We will continue to break it down if it is what the subscribers want to hear, because we got to give the people what they want. That's all we got for this one. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed this episode, please hit the thumbs up and share with your friends who might be interested here on YouTube. And of course, don't forget to subscribe to our channel. You can also follow us on all social media: Twitter, Facebook, TikTok, at Lawyer You Know. But on Instagram, we are still at Tragos Law. So look us up on there. And don't forget to listen to the Lawyer You Know podcast, available on all major podcast platforms. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us, lawyeryouKnow@gmail.com. Of course, all of these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.